Hello and welcome to today's webinar, Avoiding Elder Care Catastrophes Part 2. Today we're going to talk about the 3 critical documents that everybody should have. First, I'd like to introduce our host, Robert Slutsky. Rob has practiced elder law since 1992 and was one of the area's first elder law attorneys. He's represented for-profit and not-for-profit senior care providers and also the Pennsylvania Department of Aging. Rob has been the trusted solicitor for the Montgomery County Office of Aging and Adult Services and the Area Agency on Aging for Montgomery County for well over 15 years now. So, Rob, today we're going to talk about the 3 critical documents that everybody should have: wills, living wills, and advanced directives and powers of attorney. And I guess to start us off, could you tell us a little bit about wills? And what we're hoping to find is what they are, why you need them, and should everybody have them?
Okay, well, first of all, what is a will? A will is simply what we call a testamentary document, and essentially what a will does is it disposes of the property that is in your name alone when you die. While you're alive, a will doesn't do anything other than give you peace of mind. But what it does is it directs the distribution of your financial property, something that has a title on it, and it says who's going to manage that property. The person who manages that property is called the executor in the will, and a will can also have another type of instrument inside of it called a trust, which is really a discussion to have at a separate time, because trusts themselves are an entire seminar topic. But essentially what the will does is if you have a piece of property like a bank account or stocks, bonds, real estate that does not have a beneficiary designation, then the will determines where it's going to go, in what proportion, and to whom is going to receive it, whether that's family, friends, charitable organizations, and the like.
So why is this important for the average person? I mean, I know if you're a multimillionaire and you've got lots of assets, that's a critical piece of paper to have. But for the average person, I mean, doesn't everything just go to your spouse? Or if your kids like each other and get along, why do you have to bother with this?
Well, there's a number of reasons, and probably the answer to the first question is, does it automatically go to your spouse? It does not. It depends on how property is titled and held. So if you have a property or an account or a piece of real estate that is joint with your spouse, yes, it will go to your spouse because it is not controlled by the will. The will only controls assets that are in your name alone. Why do you need a will? Well, for a number of reasons. First of all, you want to make choices. A lot of times people just assume things are going to happen, as you did when we talked about going to your spouse. But you want to be able to make the choices and be clear about what you want. Second, that may not be your choice. You may choose for whatever reason. Maybe it's a second marriage. Maybe your spouse has independent assets of their own and you didn't want to give them everything. Maybe you have a child or someone who you want to benefit that needs some structure, that shouldn't be getting the money directly, so that the will allows you to control the distribution potentially over a period of time, like when they're age 25 or older, so it can be held in trust while they're minors. Maybe you have a loved one who's irresponsible with money and you want to name a trustee to manage the money for their benefit but not give them direct access. So there's multiple reasons why you would want to have a will. And also, the law that would govern your assets if you don't have a will is called the intestacy law. And that intestacy law may not, in fact, carry out the wishes that you have. While intestacy law generally will give a portion to a spouse and a portion to your children, you may have preferred to have all of your assets go to your spouse or all of your assets go to your children. And not everybody has a spouse. Not everybody is married. Yet, in fact, if someone isn't married but they want to benefit another person who they have a relationship with, if there's no blood relation, then a will is a necessity because the law isn't going to guess what you want to happen to your funds.
Right. Wow. Go ahead. I'm sorry.
Well, no, and that kind of answers the next question on the slide, which is what happens if you don't have a will. The government or the state makes a will for you. It's you die intestate if you die without a will, and the intestacy law makes some assumptions that are not necessarily applicable to many people. If you, again, have a second or third marriage and you have children from a first marriage, it's not a given that you want to necessarily benefit your spouse. You may have come into the marriage with separate assets and have no expectation or desire to give all your money to your current spouse. You may want to give all your money to your children from your first or second marriage. So there's a lot of reasons why you want to make decisions. A will is you acting to make your own decisions as against the government doing it for you.
And that you just definitely convinced me to do that. So, wills are great to know that after you pass on that your wishes are being met. But one of the questions that I hear a lot is about living wills and something called advanced directives. So the question that I hear is, I guess if you can explain what exactly a living will is, and I'll ask you the first two questions together. Is that the same thing as an advanced directive?
To most people, living will or an advanced healthcare directive are in fact the same thing. It's really just a different word or term for the same goal, which is, in those cases, it's healthcare decision-making towards end of life. This is as opposed to a healthcare power of attorney, which deals with healthcare decision-making, but overall, as opposed to when you are at end of life.
So can you give me an example of how those two are different? So in other words, one is obvious for end of life, right? I want to be kept on life support or I don't. But you're saying there could be other healthcare decisions made along that process.
Yes, because for most people today who get to older age, as we'd like to call it, there is the risk of what we call cognitive impairment. Other people know it as dementia or Alzheimer's or some form of deficit where you can no longer make safe decisions for yourself. Now, this doesn't necessarily mean it'll happen in old age. Some people who have cognitive impairment have it for different reasons at a younger age. Some people may have mental health issues or mental illness, or because of an injury, have a cognitive deficit, can't make decisions, can't think, have short-term memory loss. So for those people who may not be at end of life, who may be physically okay or simply physically in not so good shape, but not near the point where the discussion of your death is current or is a current issue, those people still may need help in decision making. So when I do a healthcare power of attorney for a client, it really has two components. The first component is general healthcare decision making if I am unable to make those decisions. The second component is what we're describing here is the living will or the advanced directive, where we're really anticipating that at some point in our life, we will be at a point where additional healthcare will be what they call futile. It will not help me bring back to a reasonable quality of life, and that regardless of what level of care I get at that point, it is likely I'm going to die regardless of that level of care. So that's where we're talking about the living will, where we're seeking to guide our loved ones and our medical care providers to say, look, if I am ever in a condition where basically giving me more care is not going to help me, it's only going to prolong the dying process, I want to express my wishes. I want to take control, and I want to say ahead of time, while I am able to consider all the options, here's what I don't want you to do to me. I want you, for instance, to give me enough medication to keep me comfortable, to allow people to give me comfort measures and comfort care, but I don't want aggressive treatment if the aggressive treatment is only going to prolong the dying process, make me suffer, make my family suffer. That's as opposed to, hey, I am cognitively impaired. I suffer from Alzheimer's disease at age 90, but I'm not near death. I'm simply in need of medical care, and someone has to direct that medical care. But I'm unable to do it because the Alzheimer's disease has affected my cognition.
So it sounds just a lot like a will. This gives me control over what's going to happen, except instead of to my assets, to my person at a certain point in my life when I can't make those decisions. And if I don't have a living will in place or an advanced directive in place, who then makes those decisions? Is it the doctor? Is it my family? Is it a roll of the dice?
Okay, well, everything that we talk about today and any time we talk is based upon my local experience because I'm a Pennsylvania licensed attorney. So when I give a perspective, it is based upon my understanding of Pennsylvania law. So in Pennsylvania, if someone does not have any sort of health care directive, then a law that was passed in 2007 called the Healthcare Representative Law kicks in. In this particular case, it gives a hierarchy of individuals who can make decisions for you from a healthcare perspective, although it's more restrictive than you could allow in your own written document. But essentially, it sets a list of people that have the first priority in making decisions for you. Typically, that is the spouse. Now, if it's a second spouse and you have children from a first marriage, that spouse is on equal footing or has equal priority to the children of the first marriage. And then it goes kind of in a commonsensical fashion to blood relatives, meaning children of the first marriage, then children of a subsequent marriage. If there are none of that, it goes to parents, then it would go to siblings, and then beyond that, the law is kind of unclear, and it says anybody who knows your wishes, which, really isn't, you probably want to make your own decisions at this point. So it puts in place alternatives, but for most people, those alternatives may not be the right choices, and that's kind of why you really would prefer to have made your own choice and define who you trust and who you have confidence in to make good decisions for you.
Right, and I can just hear from these examples just I can just picture the conversations where people disagree or have different, moral perspectives on what should or should not happen. So it sounds like it's really important for everybody to have that lined up in advance, regardless of age. Now, one of the things I've heard from friends and other situations is that there's different kinds. I'm sorry, I just skipped ahead there. Let me ask the final question I had here, which was, what happens if I change my mind? So if I decide, for example, that I don't want any special measures to be taken, and as I get older, I realize that really wasn't really what I want. And maybe I don't make that decision until I'm very, very sick and I can't get to an attorney to change it. Am I locked into that forever?
Well, when you say change my mind, that implies that you are still cognitively intact. So one of the unique provisions in the healthcare directive or healthcare power of attorney law that we have in Pennsylvania is that these documents can be revoked pretty much in any fashion at any time. So if you're in a hospital and you have the ability to communicate with your healthcare providers, you can simply say, I want you to destroy my living will or my healthcare power of attorney. I want it nullified. I don't want it anymore. As long as you are, again, cognitively intact. Now, the law does not specifically say you have to be cognitively intact, because the law even allows people who are not cognitively intact to undermine or countermand decisions made by their healthcare agent. So that's one of kind of the little quirks in Pennsylvania law, is that even if you are what you and I would be called not in a great condition to be making decisions, you could still revoke your power of attorney and still communicate your wishes. So as a planning tool, a power of attorney for healthcare is a great tool, but it's not infallible. Sometimes the individual can undermine good decisions made by the person they've appointed to help them by simply undoing their choices.
Right.
So, it's good to have a power of attorney for healthcare, but it doesn't give you 100% guarantee that there's never going to be a problem with decision-making or conflict.
Right. So something that I could say myself that I wouldn't have said when I'm in my right mind. But for the most part, it sounds like it really prevents a lot of problems.
Look, it works probably 85 or 90% of the time or even more. In rare cases, people's cognitive impairment hurts their decision-making so badly that they act irrationally, and they undermine the person who they named to help them, that a person's ability to help them. But in most circumstances, again, 85, 90%, maybe even more of the time, they allow the help, and the decision-maker is allowed to assist them, and it does the job. But there are situations where it's not going to work. So if you change your mind, you have a right to change your mind. The question would be, though, if you choose, when you are cognitively impaired, to revoke your old healthcare directive, you have the ability under Pennsylvania law to do that. The problem would be is at that point you may not be able to legally enact or execute a new healthcare directive, because at that point, the ability to execute the document and to make it a valid document are in question, and the law does prevent people who lack capacity to execute new documents.
Right. So as an elder law attorney, when people come to you, I mean, these are some complicated choices. Do you help step people through that process and help them really just kind of think through the decisions that are best for them?
Well, certainly it's not my place to tell people what they want, but what I do is I go through what the purpose of the document is so they understand what authority they're granting to other people, and I explain some of the choices that they have.
That's
So
true.
I think that's really the best way. Again, as a lawyer, I try not to inject myself in people's decision-making process except to give them scenarios and alternatives and let them make a choice that's comfortable for them.
Terrific. And I think that's what people really want, is just that better understanding. So let's go into that final set of documents that we were talking about, which were powers of attorney. And this is something that I think for many people, you may not even be familiar with the concept at all. So if we could just kind of walk through what a power of attorney document is, and then what it does, and then we'll kind of step through what happens if there's not one in place, or the best kind to get.
Okay, so in its most basic form, a power of attorney is a legal written document where you grant someone else the ability to make decisions on your behalf. That document, as we just discussed, could relate to healthcare decisions, or it could relate to financial decisions. And the document defines what decisions you allow the person to make. Healthcare documents, healthcare powers of attorney, tend to be more standardized in the way that they're drafted and what they do. But financial power of attorney documents tend to have more variety in the way they're drafted and what they authorize. So that's where you probably tend to get into more difficulty. You know, a power of attorney, for instance, could be very limited to, for instance, a particular transaction. I, Rob Slutsky, grant Fiona Middleton the ability to execute legal documents at a real estate settlement. And I limit it to that purpose because I know I'm going to be out of town, and I trust Fiona to do everything. She knows what the transaction's about. She knows what the closing costs are going to be, so she can go and execute all the necessary documents. For estate and protective planning, we usually don't have documents that are that limited. Actually, to the contrary, we want documents that are as broad and comprehensive as possible. So I want to give Fiona Middleton the ability, if I'm thinking about my future incapacity, my inability to make decisions, I want to give Fiona the right and ability to make as many financial decisions as possible, because your next question there is, what happens if I don't have one?
Right.
Well, what happens is, if you don't have a well-drafted, comprehensive power of attorney, if the document doesn't list all of the necessary powers, meaning your ability to access my bank accounts, my investment accounts, my real estate, to file lawsuits on my behalf, to defend lawsuits on my behalf, to get to forward my mail, to access a safe deposit box I might have. If I don't give you the authority to do those things, and then I become cognitively impaired and can no longer manage my stuff, the problem is you now have to go to court and have a legal guardian appointed for me because that document lacked the necessary authority for you to help me. And a guardianship is not something we prefer because, first, it's costly. You need an attorney to do it. And second, probably more important than the financial cost, is that once a judge is involved and they're looking over the shoulder of the legal guardian, the flexibility that a financial power of attorney allows in asset management and particularly in asset preservation planning is very, very limited. Judges will not allow people to do some of the things that I might recommend a client do for their loved one in a guardianship process. So the idea is that the power of attorney, particularly on the financial side, allows a great deal more flexibility as long as the document itself is comprehensively yet specifically drafted, meaning we want it to cover all different types of assets, but when we do that, we also want to make sure that the powers that are given are very specific and broad. So we don't want to just say, I give Fiona access to my bank accounts. We want to say, I let Fiona open, close, deposit, withdraw, transfer money in, transfer money out, create CDs, invest in all different forms of investments and things like that. We want to be as broad as possible so that we don't tie the hands of the person that we're asking to make decisions for us.
Right. So if I'm a daughter or a son caring for an aging parent, I want to be able to decide, for example, do we get home care, or do we sell some assets to pay for that home care, or do we move into an assisted living? And these would be all decisions that would need to be covered by the document.
Exactly.
Great.
And you mentioned, and again, I'm just looking at your slide here, but it says, which is the best type of power of attorney? There is a term that people use called a durable power of attorney. And again, this is state specific, but a durable power of attorney is a power of attorney that continues to be valid once you become cognitively impaired. You have to understand the history that powers of attorney were not historically used in the estate planning context. Originally, they were documents for business people, and they were used in isolated, specific instances to transact financial business. Today, powers of attorney are used because most people are living longer and at some point may have cognitive impairment and need someone else to manage their affairs. So back then, the concept of durable versus non-durable was relevant because there was a question, if I just gave Fiona the right to make real estate decisions for a particular property, I didn't want to give her the right to do that forever. I just wanted to do it while I was away on business and needed her to go to the transaction. Today, the concept of durability is very, very important because for most people, the focus or the purpose you're getting this power of attorney for is so that if you can't do things, this person can do them for me. So today we absolutely want your power of attorney to be durable if you're using it for estate planning, because if it expires when you become incapacitated, then it's of no use to anybody. You're forced to get a guardianship at that point.
Right.
What we want is a durable power of attorney. What most people, even practitioners in Pennsylvania, don't even know is that since 1992, all powers of attorney in our state are in fact durable. They all survive incapacity unless the document says specifically that they do not. So even though people kind of assume, do I need a durable power of attorney? If you've gotten a lawyer to draft you one in Pennsylvania, you probably have a durable power of attorney unless the document was drafted either badly or for a specific purpose and it was not intended to survive your incapacity.
Got it. Got it. And I guess the final question kind of on this is, can more than one person have that power of attorney? So suppose I have 2 or 3 children. Can I make both of them, or is it an either or?
Yes, you can. You can appoint as many people as you want as your agents, and it depends on your family situation and the family dynamic. Ideally, you want to appoint people who you feel will work as a team well. You don't want to get people who are going to be in constant conflict. Another thing, and this is what I see, unfortunately, sometimes with general practitioners who don't focus on the estate planning and elder law arena, is I see people making everybody co-powers of attorney, co-agents. That can be a challenge because people are not always physically local. When you appoint someone as a co-power of attorney or a co-agent, then they are bound to execute every single transaction together, so that you can't have one do your banking and one do your investments. You've got to have both do the banking and both deal with the investments and both be at the real estate settlement on a piece of property that has your name on it, because they're both bound to sign and execute every document and transaction. So I tend to, again, based on the client telling me that it sounds like a good plan, I tend to have the situation where people are or rather than and. So they are all named concurrently as agents under the power of attorney, but they're not compelled to be at the same transaction at the same time. That assumes, though, that you trust all of them equally and that you know that all of them will communicate any of their actions to the other, so everybody is kept in the same loop.
Got it. Wow. Again, lots and lots of things to think about and some fantastic information. So it sounds to me, Rob, like these documents all kind of knit together to make a whole, like a whole fabric, that you really need all of them because they all have a different purpose. So my question is, there's, today's world of Google, we can just, find a template online and plug in your name and your other family members' names, or use one of these online law services that seems so inexpensive. What do you feel about doing that? Is this something that the average do-it-yourselfer can do on their own?
Well, and I guess it really depends on the do-it-yourselfer. To be honest with you, I always make a joke when people ask me this. It's like, you can perform your own surgery, but do you want to? And, it's kind of the same thing. Um, when people call me and ask me what I charge for fill in the blank, a will, a power of attorney, whatever, I try to be respectful, but what I say is, I'm not charging you for the paper. I'm not charging you for the document. I'm charging you for the 24 years of experience and the questions that I ask and the things that I have been exposed to. Yes, you can get documents online, and yes, you can go to wills.com or LegalZoom or whatever. And you know what? Sometimes their documents may be adequate. I don't know. I've never really checked them out. I'm assuming that a lawyer somewhere may have put together a form. The problem you get is that that's not planning. That's a document. And if all you want is a document, they may or may not be adequate. I don't know how state-specific they are, and I don't know, whether they've been tested going to a bank in Pennsylvania and whether somebody has assessed them and dealt with that. What I do for a client is more than just documents. It is asking questions. It's analyzing a situation. It's explaining the potential repercussions of a particular course of action. It's a lot more than simply taking a form document and filling it in. And by the way, I tweak my documents every time something happens where I think that it would benefit clients. Since wills.com or LegalZoom doesn't get the benefit of contact with the client after the document has been executed, they don't get the benefit of being able to fix problems that can occur. They can only wait until there's a lawsuit that ultimately turns into an appellate case that one of their attorneys may find at some point. But the focus of having an attorney is the legal counsel. It's not just the documents. Although I think my documents are frankly better than something that is pulled off the internet or bought at a Staples or an Office Max, because my document comes from years of actually dealing with guardianships and dealing with older adults and incapacitated persons, and having molded the documents to try to avoid problems and conflict that can come from just, history and life.
Right. It's just not a template, which is what you're getting online. So it sounds like you've actually answered that third question too, which is, what is the best way to make sure my wishes are fulfilled? And that would be sitting down with someone who is trusted to have these conversations.
I think so. I mean, I wouldn't be doing what I'm doing if I felt like I wasn't providing value to my clients. And I think my clients find the value, because so many times when we're done the conversation, they're like, that was something I didn't think about when I was coming in here.
Right. Well, I
So
know
that makes me happy.
Yeah, I mean, I know I've learned, and I'm sure everybody listening has learned an awful lot just on this one webinar. Just things to think about that never cross your mind. So, Rob, I want to thank you and thank everyone for joining us today. And I will tell you that Rob I've known for many, many years, and it does an amazing job stepping you through the process. So if you are looking for any of these documents or have other elder law issues or need that help in estate planning, Rob handles the general estate planning, long-term care and medical planning, what to do in a crisis if all of a sudden something happens unexpectedly. The documents, of course, that we just talked about, and trusts, which I trust we will have as another webinar following this one. He also helps with people who are maybe going into a nursing home and want to look at how to protect their assets when they're looking at possibly needing to go long-term and eventually use Medicaid. For those who did not pre-plan, Rob handles guardianships and helps with cognitive impairment management, special needs planning, trusts, estate administration, and real estate transactions. Rob, you just do it all, don't you, when it comes to elder law?
When it comes to elder law, I do it all.
Do it all. I think that will just wrap us up for today, but we really want you to watch this spot to learn more. We will have more webinars coming up with Rob and his expertise to help you underway. Thank you so much.
Have a good day.
Thanks.